You open that envelope, read the decision, and suddenly, it feels like the whole system is just working against you. Getting a denial for Social Security disability benefits is incredibly frustrating. But here's what you absolutely need to know right out of the gate. Your upcoming hearing? That is actually your strongest opportunity to win your case. Today, we're going to break down exactly how to prepare for your SSDI hearing, what you can expect, and how the right strategy can literally turn a denial right into an approval.
So, you've gotten that denial letter and filed an appeal. What happens next? Well, your next critical step is the hearing process. And honestly, knowing exactly how to prepare for this is going to significantly increase your chances of success. It's totally normal to find yourself asking, okay, what do I do now? Especially if you don't have a legal background. But you don't have to navigate this blind. Understanding the landscape of this hearing is your very first major step toward taking back control of your Social Security disability insurance claim. Facing your SSDI hearing. Let's start by looking at what this legal proceeding actually entails, breaking it all down into plain English so you know exactly what you're walking into. The hearing is held before an administrative law judge, or ALJ. Now, this is a judge directly from the Social Security Administration, and their sole job is to review the unique facts of your specific medical condition and your work history. Logistically speaking, this hearing is usually held within 75 miles of your home, or, it can even be conducted by phone or video. The absolute most crucial point here is that this judge is there to look at your specific daily reality, not just stare at a stack of paperwork.
Now, when you hear words like hearing or judge, you might immediately picture some dramatic courtroom trial on TV, complete with a jury and hostile lawyers trying to trip you up. But let me stop you right there, because unlike a courtroom trial, an SSDI hearing is completely informal. It usually lasts just 45 minutes to an hour. There's no jury, and you are not going to face any hostile cross-examination. It's simply a structured conversation to get to the absolute truth of your limitations.
What to expect inside. Let's take a mental step right inside that hearing room and look at the key players and the specific situations you're going to face on the big day. Aside from the judge, there's likely going to be another person in the room called a vocational expert, or VE. Their role? Well, they evaluate your work history and suggest potential jobs they think you can still perform despite your medical condition. They're basically making educated guesses about your capacity to work in the national economy. And understanding their role is totally vital, because their testimony can literally make or break your entire case. Let's walk through a real-world scenario you'll probably face. Imagine the judge looks at you and asks, "How long can you sit before you need to stand up?" Under that kind of pressure, you might naturally freeze up. Or, just out of habit, you might say "not long," or even downplay your pain because, hey, you're used to just powering through it. But general answers, those don't win cases. As your Fresno Social Security disability lawyer, Peña Bromberg will prepare you beforehand to confidently and accurately explain exactly how your pain flares up after, say, 20 minutes of sitting. We make absolutely sure you know how to articulate your daily limitations so the judge truly understands the physical or mental barriers you're dealing with.
And here is another critical scenario. Let's say that vocational expert claims you can do a specific light-duty job. But, based on your actual medical condition, your physical reality makes that absolutely impossible. You can't really argue with them effectively on your own. If that happens, Peña Bromberg steps in immediately to cross-examine that vocational expert. We dismantle that argument on the spot, ensuring that all the evidence actually aligns with your real-world limitations. We are right there to protect your claim when the technicalities get complicated.
Strengthening your disability claim. Because before you even set foot in that hearing room or log on to that video call, there is vital groundwork to lay. To win, you really need a strict checklist for credibility. First up, you've got to continue your medical treatment and therapy. Gaps in treatment signal to the judge that your condition might not be that severe. You also need to bring updated medical records and doctor's opinions, provide a highly detailed work history, and supply a personal statement. Most importantly, you have to avoid any inconsistencies between what you're saying and what your medical records state. Make sure all new diagnoses are submitted on time. Gathering and organizing all this without messing up can be super overwhelming, which is another area where having our team properly prepare your file is just a complete game changer. It is all about painting a consistent, undeniable picture of your disability.
Why Peña and Bromberg? Now, you might be wondering if you really need help to do all of this. Statistically speaking, claimants with legal representation are far more likely to win their cases at a hearing than those who try to go it alone, which is exactly why having an experienced team to argue your case persuasively is so vital. Just take it from our client, Thomas Dozier. He told us that we, and I quote, "made it happen for me after 5 denials. Young man knows what he's doing. Thank you." We've helped hundreds of clients successfully navigate this exact process across California's Central Valley and the Bay Area. Even folks who felt completely hopeless after multiple previous denials found success when they finally had the right strategy and the right representation in their corner.
As the Social Security disability insurance expert since 1984, Peña Bromberg knows exactly what judges look for. We know the exact questions they ask, we know how to handle those vocational experts, and we know exactly how to prepare a compelling case. If you've got an upcoming hearing, contact us today for a free consultation at 559-439-9700 so we can help you walk into that room with absolute confidence. I'm going to leave you with this final thought. Your medical condition has already changed your life. But are you going to let a simple denial letter dictate your financial future? Or are you ready to bring in the experts and finally take control of your hearing?